Good morning, everyone. Thank you for joining us for today's webinar, He Said, She Said, They Said, Me Too, Best Practices for Managing Workplace Sexual Harassment Claims. My name is Lindsay Fiore. I am a partner in the Labor and Employment Group here at Quarles. I focus on employment litigation, handling single and multi-plaintiff employment cases involving age, sex, race, disability discrimination, sexual harassment, hostile work environment claims, retaliation, wage and hour issues. I handle suits brought by the EEOC and have defended against unfair labor practices before the National Labor Relations Board. I am co-presenting today's webinar with Lindsay Davis, who is also in the firm's Labor and Employment Group. Lindsay's practice covers a broad range of issues involving counseling, discipline, and discharge of employees, workplace investigations, and state and federal employment discrimination law. Lindsay has extensive experience in the areas of disability law and family medical leave laws and provides clients with practical solutions to their employment-related needs. So I'd like to welcome all of you to the Lindsay and Lindsay show this morning. We are very pleased to be with you today. We have a few housekeeping items to go over before the presentation starts. We will be applying for 1 hour of CLE credit. If you're an attorney and you would like to receive CLE credit for attending today's program, please fill out the CLE form located at the back of the PDF copy of materials that are found in the handouts panel of the webinar dashboard. Please complete the form and return it to Meg Smeck, whose contact information is listed at the bottom of the document. There are also our certification forms for use by human resources professionals in these materials. Additional items to know, we have muted all phone lines for those dialing in and for participants listening to audio via computer, so you will not be able to speak. We are in listen-only mode. And we would like you to be aware that this presentation is being recorded and an electronic survey will be emailed to you after the program. If our webinar participants have a question today, and we encourage you to submit those if you do, please type your question in the Q&A box located in the upper right corner of the webinar dashboard and submit. The conference host will make sure that the speakers receive the message. Every effort will be made to answer questions in the final minutes of our time together today.
Okay, thank you, Lindsay, and thank you, participants, for joining us today. As you can see, we've got an action-packed agenda ahead of us. We're going to kick things off by talking about the Me Too and Time's Up movements. And then we'll talk about the impact of those movements, including to discuss proposed and enacted legislation, the impact on the volume of legal claims we've seen as a result of these movements, and an uptick in suits alleging inadequate investigations. I'll then turn it back over to Lindsay for a discussion of best practices for employers, which will include addressing your anti-harassment policies, conducting training, and investigating and resolving allegations of sexual harassment. So let's start off with the Me Too movement. What is the Me Too movement? It's a viral social media campaign to demonstrate the widespread prevalence of sexual assault and harassment, including in the workplace. The Me Too movement started, or really gained traction following public revelations of numerous sexual misconduct allegations against Harvey Weinstein. Since October of 2017, when those allegations came to light, the phrase #MeToo has been posted online millions of times, usually accompanied by a personal story of sexual harassment or assault. As I mentioned, these have included personal stories involving workplace harassment. Below, you'll see 2 tweets from employees regarding issues that occurred in their workplaces. The first, my supervisor asked me to step into the bathroom so he could show me how to do the inventory. He pinned me against a wall, #MeToo. The second, the owner of the first company I worked for felt it was appropriate to rub my shoulders while I worked and called me baby. I was 17, #MeToo. You can see that these tweets are ones that are containing detailed allegations of sexual harassment. And in some cases, though not shown here, employees at various companies have identified their companies by name in their tweets or other social media posts. Shortly after the Me Too campaign went viral, a number of Hollywood celebrities founded what is known as the Time's Up movement. This is another movement meant to combat sexual harassment. Its founding initiatives include a legal defense fund to support lower-income women who are seeking justice for sexual harassment or assault in the workplace. The members of the Time's Up movement are also advocating for legislation to punish companies that tolerate persistent sexual harassment. The Time's Up movement has raised over $20 million for its legal defense fund and gathered over 200 volunteer lawyers to provide services to those alleging sexual harassment or sexual assault. Without a doubt, these campaigns have raised awareness regarding the prevalence of sexual harassment, including in the workplace. But one question is whether their impact has been further reaching. From what we've seen so far, and again, it's been less than a year since this all kicked off, we have seen an impact of these movements in various spheres. The first thing we're noticing is that these campaigns have had a legislative impact. I'll talk about both federal and state legislation that's already been enacted and in some cases has been proposed, beginning with the Federal Tax Act, which became effective December 22nd of 2017. Now, ordinarily, employers are permitted to deduct ordinary and necessary business expenses when doing their taxes, and this has included settlement payments and legal defense fees. But the government pursuant to the Tax Act, the government will no longer permit employers to deduct any settlement related to sexual harassment or sexual abuse or any related legal fees if the settlement is subject to a non-disclosure agreement. So what this means is that employers who are subject to the Tax Act are going to now need to carefully consider the use of confidentiality and non-disparagement clauses, which had normally been commonplace clauses in any type of settlement agreement, where the claims involved include sexual harassment. This is relatively new legislation, and we're awaiting what we hope will be further guidance regarding the contours of it. But for now, best practice is when you're resolving claims involving sexual harassment, you'll want to consult with your legal counsel regarding what terms will be appropriate in that settlement agreement and whether or not the funds issued as part of that settlement agreement can or will be deductible. In addition to the Tax Act, Congress has also introduced legislation that would make it illegal for businesses to enforce arbitration agreements if employee allegations involve sexual harassment or gender discrimination. What we're seeing is this proposed legislation by Congress has caught traction, and in fact, numerous states are proposing similar legislation. In fact, just a few days ago, New York passed its budget bill, which added several anti-sexual harassment provisions, one of which was a provision that limits the use of non-disclosure agreements in sexual harassment cases. Essentially, under the New York law, disclosure is now the choice of the complaining party. In addition, New York's budget bill also included a ban on the use of mandatory arbitration provisions for sexual harassment claims and a requirement that employees conduct annual sexual harassment training. Many other states have introduced similar bills, including New Jersey, Pennsylvania, California, and Washington. Time will tell whether those bills will pass, but certainly the New York legislation gives us some insight on what we think will occur. The second impact that I want to talk with you about is whether the Me Too and the Time's Up movements have resulted in an increased number of claims by victims of sexual harassment. Anecdotally, what we know is that many employers are reporting an uptick in internal complaints. And this is likely because these social media movements have helped to destigmatize speaking out against sexual harassment, including workplace sexual harassment. The result has been that employees are now more likely to take a hard line against workplace misconduct and to advocate for themselves and for changes in their workplace environment. Now, have those internal complaints also resulted in an increase in claims with administrative agencies or with the federal courts? I think it's too soon to tell. So far, the EEOC is reporting that they've seen no significant change in the number of sexual harassment claims filed, but at the same time, they're also reporting that they have learned of increased employee demand letters, which suggests that if those claims aren't ultimately resolved, we'll see an upsurge forthcoming. A lawsuit for sexual harassment is not necessarily a foregone conclusion. I think another thing that we're seeing is many employees who are engaged in the Me Too or the Time's Up movement are interested in seeing what their employers will do with regard to internal claims of sexual harassment. And another thing we're seeing is that in many cases, the allegations being brought forth are outside the statute of limitations. You saw from the tweets that I had posted earlier, those are alleging incidents which seem to have occurred many years in the past. But where lawsuits are the result of these sexual harassment claims and those lawsuits are successful, the resulting damages can be very significant. Just by way of example, let's start off with going back to the media outlets, which kicked this all off for us. In January of 2017, many of you, I'm sure, heard about Bill O'Reilly and the sexual harassment allegations brought against him. Bill O'Reilly and Fox ultimately settled those claims of sexual harassment for $32 million. And it turned out that that was the sixth such settlement relating to O'Reilly. Despite its knowledge regarding the pattern of sexual harassment allegations against O'Reilly, 21st Century Fox then extended his contract. When all of these settlements subsequently became public knowledge, Fox lost numerous advertisers who boycotted O'Reilly's show, and this ultimately resulted in his ouster. Around the same time, we learned of numerous allegations against Roger Ailes. This began with a former broadcaster alleging that Ailes had sexually harassed her. When she refused to sleep with Ailes, her employment contract was not renewed, and she ultimately brought a lawsuit alleging, in part, sexual harassment. She received a $20 million settlement, and then Ailes ultimately resigned, receiving a $40 million severance package himself. Even after Ailes had left Fox News, numerous additional lawsuits followed, which tells us that Fox News is not yet done paying for the sexual harassment that occurred under Ailes' tenure. But it's not just powerful media outlets who are getting slapped with huge damages for sexual harassment claims. It goes well beyond Hollywood and media outlets and impacts run-of-the-mill employers as well. So in the case Ashley Alford versus Aaron's Rents, the plaintiff in that case ultimately received a $41.3 million damages award. She was a retail chain employee who had made complaints of sexual harassment against her manager, contending that he had harassed her. Unfortunately, her employer largely ignored those complaints until the manager sexually assaulted her. Her federal court lawsuit followed, and as you see, she received a significant damages award. Another example is the case of Carla Ingraham versus UBS Financial Services. Carla was a client service associate at this financial services firm, who alleged that a male broker was making sexually inappropriate comments to her. After she brought those comments forward to management and HR at her company, she was fired. based on the facts of that case, she ultimately received an $8.5 million award. These large damages awards tell us one thing, and I think one thread that is common to them is that the damages can be significantly greater when employers fail to take appropriate action to respond to internal complaints of sexual harassment. And taking that one step further, we've seen an uptick since the Me Too and the Time's Up movements of respondents actually bringing suits following their employment separation or their receipt of discipline in which they allege that the companies conducted inadequate investigations. One example is the recent case of Pharmac Inc. versus Metropolitan Opera Association. In that case, a top company officials were notified of complaints against the plaintiffs on numerous occasions. In the midst of a social media scandal, the company finally decided to investigate after the police got involved. They ultimately fired the plaintiff, and soon thereafter, he brought a suit alleging that he had not been given a reasonable opportunity to respond to accusations against him. He is seeking $5.8 million in that lawsuit, which is currently pending. Another example is the case of TS Media versus Public Broadcasting Services, this one involving PBS, obviously. And in this case, PBS investigated complaints of workplace misconduct that were brought against one of their talk show hosts. During the investigation, at least as alleged by the respondent employee, PBS failed to inform him of the names of his accusers or the specific allegations against him, and at the close of their investigation made the decision to separate him from his employment. He filed suit alleging that PBS engaged in essentially a biased internal investigation that violated the norms and procedures for conducting workplace investigations. As in the previous case, he is seeking a significant amount of damages alleged to have been suffered as a result of this inadequate investigation. So that's sort of the background regarding the Me Too and the Time's Up movements. I'm now going to turn it back over to Lindsay, who will speak with us about what employers can do to limit risk in this new terrain that we're seeing as a result of these viral anti-harassment campaigns.
Thank you, Lindsay. The number one question that we're getting through all of this is, what can I do? And there's a lot, and a lot of you are already doing it. Some things can be. It's always a good reminder of best practices, and that's kind of what I'm going to go through with you today. The first and probably most important thing is establishing an inclusive atmosphere, and that's, when we say that, I'm talking about the culture of the company. Everybody has a policy that says we don't permit sexual harassment. It's prohibited. We prohibit retaliation, response, or reporting it. But this is more than just having a policy. And it's having a policy, but it's also enforcing it. It's applying it consistently. It's taking complaints seriously and taking action. There is a lawsuit pending right now that was just recently filed against Google in California. A former female engineer has alleged that Google sort of maintained this quote-unquote bro culture in an industry or a field where engineering is historically and probably still largely male. Some of the things in her lawsuit are really, she says that her male colleagues spiked her drinks with whiskey and would laugh about it, that they shot Nerf balls and darts at her on almost a daily basis. She alleges in the complaint that one of her coworkers was hiding under her desk, and she found him there when she showed up to work. And he said to her, allegedly, "You'll never know what I was doing under there." She alleges in the lawsuit that she went to HR to complain, and that retaliation followed and ultimately resulted in her being terminated. And so that's kind of an example of how a company could, and of course we don't know if all these allegations are true or not, but these are examples of how a company's culture can be really important. And in the tech industry especially, there's always been sort of these types of, I don't know if it's rumors, but this idea that there is a bro culture out there, and so this type of lawsuit perhaps is not going to be unique. So companies should be acknowledging that these Me Too and Time's Up movements exist. Being aware of the risk factors for harassment in the workplace is important as well. And when we talk about risk factors, we're talking about things like, does the company have a really young workforce? Are there a lot of individuals who don't have the experience in working in business environments, professional environments, and so perhaps don't know or aren't well aware of, proper business code, proper business behavior, proper professional behavior? Is it a workplace where there are significant power disparities, or a workplace where discussions and political discourse is common that can lead to harassment of all sorts of, many different natures, not just sexual, but knowing that those factors exist can be important, and then you can take steps to minimize them. Encouraging employees to come forward, of course, if they are subject to harassment or if they witness harassment, and providing the resources for them to do that. And we'll talk more about that in a little bit. And demanding professionalism at every level, and ensuring that your managers are modeling good behavior. And this comes with training, of course, and it also comes from accountability. Thoroughly reviewing and revising your applicable anti-harassment policies will be very important as well. There are a few things that every policy ought to have in it, and I'm going to go through each of these 4 things as we go forward. A definition of sexual harassment, examples of prohibited conduct, a defined reporting procedure, and a statement against retaliation. The definition of sexual harassment, there's 2 types. There is hostile work environment, which is what we see most frequently. That is an employee subjected to sexual harassment or sex-related conduct, sexually charged conduct that is severe and pervasive enough to be abusive and hostile to affect the employee's working conditions. And quid pro quo harassment, which is where an employer, usually through a manager or a supervisor, offers an employee a favorable change in their job, perhaps a promotion or a favorable transfer in exchange for sexual favors, or takes negative action such as demoting an employee or even firing them for refusing the request for sexual favors. The definition of sexual harassment: unwelcome conduct of a sexual nature that adversely affects or interferes with an employee's work environment. Unwelcome, and this means to the recipient or to others. Two employees who are in the break room watching a pornographic video on someone's phone can certainly be harassing to someone who's sitting there nearby trying to eat their lunch. And this kind of part of the bro culture that I talked about a moment ago, certainly in that situation, what was happening to that woman was unwelcome to her, according to her allegations, but certainly could also be unwelcome to other people who are not participating but are observing it. The conduct of a sexual nature. So this means sexually oriented photographs, emails, sexually suggestive memes that are sent around company email. It can be verbal things, jokes, propositions, comments, ranking coworkers' looks, asking questions about coworkers' sex lives, making judgments about coworkers' sex lives or suggestions about them, and of course, physical conduct as well, which gesturing or touching. The conduct, in addition to being unwelcome and of a sexual nature, must have an adverse impact on the employee's working environment in order for it to rise to the level of sexual harassment under Title VII or under most state laws. However, one thing employers ought to be aware of is that just because an incident is trivial or isolated, it does not it may not rise to the level of sexual harassment under the law, but it certainly may rise to the level of conduct that is prohibited by company policy, and should certainly still be conduct that employers are acting upon when they learn of it. Harassment, I know everyone that is on the phone here today and participating in this webinar knows that harassment can be perpetrated by anyone. It is not just men harassing women, that men can be victims of sexual harassment as well, that sexual harassment comes in many different forms. It can be same gender, it can be opposite gender, it can be based on many different things. It is not limited to the traditional man harassing woman story of the past. And harassment can be perpetrated by non-employees, which is another important point to make. If the man who comes and stocks your vending machine is constantly asking one of your employees out on dates or making comments about her figure or her clothes or whatever it may be, the employer's responsibility, it's not simply, well, we throw our hands up, he's not our employee, what can we do? If there is a person on your premises, in your employees' workspaces, and they're engaging in conduct that would violate your anti-harassment policies, there is an obligation, and in the eyes of the law, it doesn't matter that that person is not your direct employee. And of course, harassment can include off-duty conduct as well. Your policy should have examples of prohibited conduct. There's several different examples here on this slide. It's helpful to employees who are reading it who may not realize that, for example, rating all the men in the office on a 1 to 10 scale based on their looks might be harassment. So it's helpful for employees to see what examples are and to understand that how far-reaching this goes, and some of these things that perhaps people don't traditionally think of as harassment certainly can be. It is important that the policy explain that the examples are not an exhaustive list. Your anti-harassment policy also ought to have a defined reporting procedure, and that means a written description of how an employee, if they're feeling harassed or they're witnessing harassment, how they're able to report it to someone in the company and have something be done about it. There should be multiple reporting channels, ideally 2 or more. You don't want to leave the employee with the only option being that to report the conduct to the person who's the alleged harasser. If it's possible to have a third-party hotline, that's also helpful, anonymous hotlines especially. Even with MeToo and even with Time's Up, there's still a lot of hesitancy out there to report this conduct, especially in a small working environment, especially when it's your direct supervisor, the employee's direct supervisor, or especially when it's a very high-level, high-ranking person. So giving employees lots of options as to how to report this is helpful. I would also suggest that although you want to have a defined reporting procedure, I would suggest that the reporting procedure doesn't limit the employee. In other words, avoid having language in the policy that the employee must go to this person or must follow this procedure. Giving them multiple options will encourage reporting. Also encourage employees to report promptly. Obviously, the employer wants the opportunity to investigate before the issues escalate or before additional people start to suffer from the same conduct or same fate. This will encouraging employees to promptly report it will also help in terms of preserving evidence, having the proper people to talk to, making sure memories are still intact. And then, of course, as the employer, the job is to ensure that the investigation is done promptly. This is really important, and the culture that I was talking about earlier, starting from the top down, and ensuring that the people who are charged with investigating these claims do so in a timely manner. Your anti-harassment policy also should have a statement against retaliation, meaning a statement that the employer provides that assuring employees that if you file these complaints in good faith or you bring these complaints in good faith to our attention, it will not negatively affect your employment. One thing that you will see not here in these anti-harassment policy musts is a statement of confidentiality. And I'm going to talk a little bit more about that later, but it may not always be possible. Certainly, ideally, you want to keep these investigations and these allegations close to home, but it's not always possible to have complete confidentiality, and it's advisable not to overpromise this in writing in the policy. Okay, so you have established an inclusive culture, you have prepped your policy on anti-harassment. How do you implement it? Training obviously is very, very important. Ideally, training should occur annually, in part because people forget, and in part because it's always, you know, the law doesn't necessarily change, but the culture does. And what we've seen even just in the last year, the way that the Time's Up movement and the way that the Me Too movement have overtaken things, it's causing a lot of people to think about everything a little bit differently. And so those annual training can account for those sort of societal shifts as well and how we think about these things. And training should be your managers and your non-managers. All of your employees should be equipped to spot and appropriately respond to sexual harassment. Your managers are on the front lines, and they are often the most likely recipients of these complaints, especially the first-level managers and supervisors. They're the individuals who are closest to your employees. They're the individuals who may have a much more friendly relationship with the employees, someone who may have been a peer with the people that they supervised last year, and they're now in a supervisory role, and there's that trust there. So those individuals are most likely going to be getting a lot of the feedback and comments of perhaps inappropriate behavior, particularly the so-called informal complaints, just the comments. So-and-so has been acting this way towards me, and it's kind of creepy. And so training your managers and your first-level supervisors to have their ear open for those sort of comments and those sort of remarks will be important. Another thing that employers can do is reconsidering the traditional approach. Consider in-person training for your employees. And a lot of companies have employees do modules online or watch a video, and sometimes this is done at the time of hire and perhaps on an annual basis. Certainly those methods can be effective, but consider in-person training as an alternative also. Having that level of interaction encourages participation and engagement. It encourages the trainees to be more focused and more attentive in what's really being trained of them. I'm sure that I would not be the only person who's ever sat through a video on anything and maybe didn't pay particularly close attention the entire time. And if you really want to have that level of engagement and have your employees really have the level of training that they need to really, especially for your managers and supervisors, to really root these things out, it may be a good idea to do in-person training. Make your training materials accessible on your intranet or in a file in HR's office. And as I said, consider bringing in the experts, meaning consider having formal training for your employees in the area of sexual harassment or any kind of employment discrimination. Investigate complaints swiftly and thoroughly. Every complaint should be investigated, and I'll talk about that more in a minute also. Promptly and thoroughly, good documentation, and good communication, and I'm going to go through each of these. investigate every complaint. This means investigate the complaints that you think might be bogus. This means investigate the complaints that might be old, especially if the harasser, the alleged harasser, is still working there. I think Lindsay touched on this a little while ago, that there are reports that perhaps the statute of limitations has passed for any legal action to be taken. But what I have seen is that my clients are interested in learning about past, maybe not mistakes, but how things could have been done differently. Even with claims of sexual harassment that are 8 or 10 years old, or even if the employee who made the claim doesn't work for the company anymore, employers want to know, what happened, and what did we do then, and what can we do, what would we do now, and what can we do going forward. Investigate every complaint also may mean investigating complaints where the employee tells you, don't investigate. What we hear a lot is, I don't want to file a quote-unquote formal complaint. There's no such thing. If an employee reports conduct that violates the law, or even conduct that violates company policy, you may have an obligation to investigate it. And part of that is because if it happens again and there's an allegation that the employer knew about it and didn't do anything, it's not a great fact to have. We've written here, beware of the serial complainers, because eventually they'll get it right. And this kind of goes back to the first point I was making, which is, even if you don't think that the complaint has merit, or this is a person who has repeatedly brought things to human resources that turn out to be unsubstantiated, this is the boy who cries wolf. It can always be the boy who cried wolf situation. And so all complaints should be taken seriously. All complaints should be investigated. And the failure to investigate a sexual harassment complaint can certainly have serious repercussions, escalating behavior by the alleged perpetrator. There are certain legal defenses. It's called the Farragher-Elleris defense, but an employer accused of sexual harassment may have an affirmative defense if the employer can show that they had a policy in place that prohibits the harassment, and that the person, the plaintiff or the employee who made the complaint, failed to reasonably take action or follow that procedure. But the employer also has to show that they followed the procedure, and certainly, failing to investigate a complaint that's made doesn't help, and that you may not be able to use that defense going forward, or even a lengthy delay in the investigation as well can be a problem. The other issue with not investigating properly or failing to investigate every complaint is setting a precedent of an unequal application of policies. We have seen cases where men complained of sex discrimination because a female employee's complaints were taken seriously, taken action, thoroughly investigated, and male employee complaints were not. And I've also, it says here, damage to the perception of culture, meaning if you've established this culture of inclusiveness and encouraging reporting, and you've got a policy that goes through all the situations that we went through already, the definition of sexual harassment, and we don't tolerate this, and we encourage you to report, and here are all the options available to you. But then when the actual report is made, nothing's done, or there's a lot of dragging of feet. Obviously, that can be very damaging to the culture that you've tried to create. In your investigations, practice good communication. And I don't, sorry about that. Practicing good communication is important, and I will get to that in a minute. Investigating promptly and thoroughly. as I mentioned a moment ago, obviously very important. Courts have found that delays of as little as 1 month were not sufficiently prompt and warranted an award of punitive damages. Immediately acknowledging the complaint and letting the employee know that you take the issue seriously, very important. Determine the appropriate investigator who's going to be handling the complaint. It needs to be someone who's not involved in the situation, and this may sound obvious, but you'd be surprised how often people bungle this. Having an outside third-party perspective is important. Eliminating any sort of implication or later allegation by the employee or the accuser that there was any kind of bias involved. And you also want the person who's conducting the investigation to have those skills. Training for your investigators is also important. Going through the proper procedures and being sure that the people who are conducting these investigations of complaints of harassment, that they have the skills that are necessary to do it thoroughly and effectively. The investigator should first interview the complainant, get all of the details, exhaust all of the incidents, ask all of the questions, figure out who all the witnesses are, what all the evidence is. That is your first stop to figuring out what all the other rabbit holes that need to be run down from there. And then interviewing the respondent and witnesses, the alleged harasser. And this is where that confidentiality part comes in again as well. The idea that, and Lindsay touched on this earlier in some of those lawsuits that have been brought against companies who fired employees for sexual harassment, and those employees shot back and said, I didn't get a chance to properly respond to the allegations against me. Employers need to provide that option for the person who's being accused, and that may mean providing details to that person that would enable that person to know who has brought the claim. But there is no way to thoroughly investigate a claim if the person who's being accused isn't allowed to, or isn't able to, or doesn't have all the information that would enable that person to respond to the allegations. It's important in investigations that the person being accused of the wrongdoing have that opportunity. Review and preserve evidence and prepare a final report, also important pieces. These written documents may eventually become exhibits at trial, and so the better prepared that they are, the more thorough, the details should all be in there, the dates, the times, and I'm going to go through that more in a minute as well. It's the good documentation. For the love of your lawyers, remember that your documents may become exhibits. Some tips for documenting interviews with witnesses. Keep it contemporaneous. In other words, if you're able to write notes as you're talking to the person, if your HR people have a laptop or a notebook and they're taking notes as they're conducting the interview, as opposed to talking to someone and then going back to an office and trying to write it all down. Stick to the facts. In other words, people often have opinions about things, and we want to be sure when we're conducting these interviews and we're getting information from witnesses that we're getting what they actually know, not what they think might have happened, not what they're speculating about. Sometimes it may be important to note what other people have told them, because those other people might also be witnesses, but it's important to include the facts and not speculation. You want to have the date, the time, the people who were there in the room, the person who is doing the investigation, the person who's being investigated, the person who's being interviewed. All of that information in the document will, if that document does become an exhibit at trial later, will be important and helpful information. And when the final report is prepared, there should be a summary of all of the evidence, what all of the witnesses had to say, what all of the documents have to say, and then conclusions that are made from all of the evidence that has been gathered. And then identifying any disciplinary or remedial measures that need to be taken as a result of the investigation. and practicing good communication. And this is what I was mentioning earlier, don't overpromise confidentiality. You may endeavor to keep an investigation confidential, but as I mentioned, some people are going to have to know, including the alleged harasser, including individuals who are eyewitnesses or otherwise witnesses to some of the conduct or comments. Companies, and I've seen companies struggle with this, but it is a reality. And we have actually seen claims where one of the allegations involved was, you promised me that you would keep this confidential and then you didn't. That isn't really a claim in and of itself, but it certainly can be, it can certainly provide some flavor for pretext, but it also is just problematic. Don't keep the it's problematic it's problematic because it can often leave your employee with the wrong impression about what's going to happen. And to that same end, don't keep the complainant or the respondent guessing. It's important during an investigation to communicate the anticipated timeline. Sometimes there are deviations. Sometimes an investigation comes in, or complaint comes in, an investigation starts. It's expected that it might take a week or a week and a half to finish it. And then one of the key witnesses, it turns out, is out of the country for 2 weeks, and it may take a month. Communicating that with the person who has made the complaint, as well as the person who has been accused of improper conduct, is important. When you've completed your investigation, communicate that to the complainant and to the alleged harasser. One thing you can keep confidential is what action precisely has been taken. A lot of times we advise clients to just explain action has been taken. But make sure that the complainant knows at the beginning of the investigation that you're not going to be able to tell them exactly what you do in response. Keeping employee disciplinary actions confidential is certainly still permissible. It's important to remind both parties, the complainant and the alleged wrongdoer, about the policy that prohibits retaliation. Encourage the complainant to come forward if they have additional concerns. And in particularly difficult cases, it may be advisable to check in with the complainant from time to time and just make sure that their work environment is still stable following the complaint. We have a few scenarios to discuss. I haven't seen any questions come in yet, although if you all have questions out there, we're happy to take them. And in the meantime, we have a few questions or scenarios that we see come up from time to time, and I will pose the first hypothetical scenario to Lindsay.
Actually, Lindsay, sorry to interrupt you. I did get a few questions that have come in, so perhaps before we jump into the scenarios, we want to take those few that we've gotten.
That would be great.
Okay, perfect. So I will just repeat the question so that everyone knows what it is, and then either Lindsay or I will provide a response to you. The first came in regarding some of those high dollar amount damages that we talked about in the first half of the presentation. The question was, the awards in these cases and the damages being sought are of a high dollar value. How are the damages so high given the federal statutory caps for punitive and compensatory damages? Is it that most of these cases are in state court? If so, what states? That's a great question. Under Title VII, compensatory and punitive damages are capped for the largest employers at around $300,000. But I did mention to you a couple of cases, obviously, where the damages awards were much higher than that. And that's because the claims in those cases were not solely under Title VII. For instance, in the first one that I mentioned, the Ashley Alford case, there were also claims for negligent hiring and other tort-like claims that resulted in the ability to garner higher damages awards. In the second case, the Carla Ingraham case, the plaintiff was able to recover a greater amount in damages because she pursued her claims in state court where the Title VII cap on damages was not applicable. The next question I'll pose to you, Lindsay, if you don't mind.
Sure.
The question was, for more trivial or isolated incidents, is it appropriate to sit down with both parties together and facilitate a discussion to work through the issues?
The answer to that is it depends. It depends on what the allegations are. It depends on what the situation is. I think, generally speaking, it may be the case that the problems between the two individuals are personality conflicts that, or serious miscommunication issues that can be perhaps resolved through some sort of informal mediation with a higher level manager or with HR. Certainly those can be effective. If it's a situation where the person who is complaining feels extremely uncomfortable about the conduct, even if you determine that it's an isolated or trivial scenario, it's probably not a great idea to stick them in the same room and put that person in that situation. So, like so much of employment law, the answer to that question is it depends, and you'll have to use your judgment as to sort of what the allegations are, how serious they are, how each person feels about it.
Yep, I completely agree. We have gotten a number of questions coming in asking whether the PowerPoint slides will be available. You should, as a participant in this webinar, you should be able to access the PowerPoint slideshow in PDF format by going to the handouts section on your screen. Of course, if you're having any difficulty accessing the materials, feel free to email us or Meg Smeck, whose contact information will be provided, and we'll be happy to get the materials to you. We can take a couple more questions. The next one that we received is, how do you recommend dealing with situations where a complaint is unsubstantiated and the employees must still work together after the investigation is complete? It's a great question. I think that it goes back to some of the things Lindsay was discussing with regard to the investigation process. The first thing that I would recommend is at the close of any investigation, no matter what result you ultimately reach, you want to be sure that you're telling both parties, reminding both parties that the company absolutely prohibits any form of retaliation. I think that where the allegations are unsubstantiated, certainly there could be a fear on the part of the complaining party that suddenly they're going to face the ear of the person that they alleged was engaging in harassing conduct. So you want to make sure you're addressing that and making sure both employees know to come forward if there are any ongoing or continuing issues. And I do think it's appropriate under those circumstances to have a wrap-up discussion with both employees, though not necessarily together, where you're sort of reminding them of the need to continue working together collaboratively in the work environment, and that we need to move forward with the knowledge that the company did a thorough investigation and that if there are any issues going forward, it will do so again.
I agree with all of that, Lindsay. And, the investigator who conducts the investigation can also offer both parties, or particularly the complainant, a direct access. If additional issues arise, please feel free to call me as a person who is already very aware of the work environment and the original complaint. Maybe another option as well.
Mm-hmm. Another question that we got in is regarding the documentation practices that Lindsay discussed. The question is, do you keep both the interview notes and the final report? Is the final report the only thing filed in the employee's personnel file, and are interview notes to be kept separately? Do you want to take that one, Lindsay?
Sure thing. So the answer is yes in terms of keeping everything. Everything should be kept for the same amount of time as you would keep a personnel file. I would not recommend putting the final report in the employee's personnel file. What I would recommend doing is having a separate investigative file that contains all the written notes related to the complaint, all of the interview notes related to the investigation, and the final report. If there's any sort of disciplinary action that comes from it, or any, a note to the file or a memo to the file that's part of the remedial conclusion of the investigation, that can go into an employee file. But the recommendation is that the investigation itself and all of the documents related to it, including the final report, are in a separate investigative file.
Mm-hmm. The next question that we received, I think also relates to the documentation issue. And the question is, would it be helpful to have the person interviewed review the summary of your interview and acknowledge that they agree with it by signing the document? It's a great question, and one that I actually have addressed with employers in the past. I think this is one where, in my experience, it seems like a great idea, but it can very easily backfire. What I have seen happen when we offer this option of employees reviewing your HR notes, your interview notes, and then confirming their accuracy, is it has a tendency to reopen the investigation and result in a back and forth where your notes no longer are your notes. They become basically a document that has been created and added to by the person that you're interviewing. I think a middle ground position here, though, is at the conclusion of each interview you conduct to do a verbal summary of what information you understood from your discussion with the employee, and ask the employee, is there anything else that you'd like to add? Is there anything that I've missed in my summary? And that way you're giving them you're having that opportunity to summarize what you've heard and giving the employee the opportunity to add anything else they may feel is relevant. But Lindsay, you may have a different take based on your experience, so.
No, I agree with that. The only other thing I would add is that it can sometimes feel overwhelming or perhaps intimidating to an employee who's complaining to make them sign something, especially if they're hesitant to come forward in the first place. And there are occasions where you're going to get complaints that are anonymously brought, even though the company may know who it is that is making the complaint. So there can be an intimidation factor as well in asking an employee to sign their name to something.
The next question we've got, and what I think may be our last question before we move on to the hypotheticals, this is an interesting one. It says, we had an associate come forward who was alleging that she had been harassed by another associate's girlfriend that did not work for us. And I think the question is, what do we do in that scenario? I'm going to go back to what Lindsay said is the common response in employment questions. And I think the answer here is it depends. I would want to know more facts, including where is the harassment occurring? Is it, being encouraged by your other employee who is, the boyfriend of this non-employee? Really, what are the circumstances here? And then you've got to go back and take a look at your policy and determine whether it's possible that this conduct is somehow violative of your policy. For instance, if it's happening on your company premises or while the employee is conducting his or her job, then it may be appropriate for you to do an investigation. I think also if you're learning of really egregious, potentially threatening or harassing conduct that's making your employee feel unsafe in the workplace, there are certainly actions that you could take and may be appropriate under the scenario, including, potentially pursuing a temporary restraining order or some other sort of injunction to make sure your employee feels safe and is able to perform their duties consistent with your expectations. Anything else to add on that one, Lindsay?
No, that was a great answer, Lindsay.
So we have reached 12 o'clock, which was our promised hour to you. And so at this point, we want to thank you all for joining us. And we are happy to stay on the line for a couple more minutes to address these hypothetical scenarios. But if you have to jump off, of course, we understand. And if we didn't have the opportunity to get to your question, we certainly welcome you reaching out to us. Our contact information is in the materials. and we'd be happy to talk with you further about your questions or the content of the presentation today. And with that, why don't we move to this first hypothetical here and spend just a couple minutes quickly discussing it.
And I'll pose this one to you, Lindsay. In the midst of the hashtag #MeToo movement, Janet, a longtime production associate at Whimsical Widgets, sent her own hashtag #MeToo tweet out to the internet universe. In it, Janet alleged that over the course of the last 3 years, a manager has sent her lewd photos and repeatedly asked her on dates via Facebook Messenger. Janet's friend and coworker Quarles sees the tweet and alerts you, the human resources manager. Should the company investigate?
It's a great question, and I think one that we have seen pop up in the context of the Me Too movement in particular. And my response to this is I do think, yes, the company should investigate based on the knowledge it has. And again, that's somewhat limited information at this point, but it does appear that there is a manager who at some point during this employee's tenure was engaging in potentially inappropriate behavior. As we had recommended or discussed earlier, it doesn't necessarily matter that the behavior may have been occurring outside of working hours or, not physically at the workplace. Your policy can govern harassment that extends outside of your traditional workday or the bounds of your facility. And again, I think you have an obligation to look into these issues to ensure that the workplace is safe for your employees and to ensure that your employees are able to productively perform their jobs. So I would recommend under these circumstances, bringing Janet in and having a discussion with her about what you learned through the tweet.
I would agree with that, Lindsay. I think this is part of the case you talked about earlier, the Metropolitan Opera case. In that case, the employer had sort of heard rumors of inappropriate conduct on the part of that individual, and even then learned of a police report and didn't really do anything until later on, and that certainly contributed to some of the issues that they're facing today.
Yes, agreed. And I think there's a part 2 to this one. In this, you make the decision to investigate, likely based on the wise counsel of your attorney at Quarles and Brady, and you schedule a meeting with Janet. When you speak with her, she confirms that Martin, who's a shift manager, has been and continues to send her inappropriate photos and messages. Again, the messaging doesn't happen during working hours or using a company device. Janet requests that you take no further action referencing a fear of retribution. Should you honor Janet's request not to further investigate?
No. This is
I agree.
This is what I was kind of discussing a little bit earlier, that you may have to investigate complaints even where the person asks you not to investigate. I would, in this case, the fact that it's not happening during working hours or using a company device, as you mentioned a moment ago, Lindsay, doesn't matter, especially because, he's her supervisor, it appears from this hypothetical, and obviously it has affected her to the point that she sent this tweet out and is considering herself part of this movement and part of, as someone who's encountered inappropriate conduct within the workplace. It's obviously affecting her. And obviously there are concerns there based on her own actions. So what I would suggest, of course, is reminding Janet that there is an anti-retaliation policy, that it is strictly enforced, obviously reminding the alleged harasser of that as well. And this kind of goes back to what we talked about a moment ago, which is sitting down and talking to the person and saying, look, we've got to investigate this, but having that good communication and letting her know that there's an obligation there, and then checking in with her to see if there are additional concerns beyond what she's tweeted. If this manager is doing it to her, he could be doing it to other people. There is definitely an obligation to investigate in that situation, regardless.
Yeah, and I would. I think that's exactly right. And I would add here that let's keep in mind the way this all came to your attention was through a very public tweet. It's very possible that your other employees saw the tweet and are aware of the situation as well. And again, you're running a real risk of damaging the culture that you worked very hard to cultivate, that employees should come forward with your concerns, that you take them very seriously, and that you're committed to providing a workplace that's free from sexual harassment if you learn about an incident like this and ultimately take no further action. So there are many reasons to pursue an investigation in this case, and the culture being just one of them here.
I agree. Great points.
Okay. Well, we will leave the second hypothetical for you all to ponder, and again, invite you to contact us with any questions you may have, again, relating to it. And at this point, we'd be remiss if we didn't mention to you that your attorneys at Quarles and Brady can provide certainly a plethora of services relating to sexual harassment claims, including review of your policies and procedures for investigating sexual harassment. And also, we offer robust training programs on many different topics, including the topic of workplace sexual harassment. So we're always happy to come on site or to do virtual training for your managers and your employees. And we encourage you to contact us if you have interest in any of those services. Thank you all again for spending your afternoon or morning with us, and we'll look forward to the next webinar.